Hey guys, oh excuse me, golly. So I haven't had anything to eat yet, or gotten up. Anyway, so the this trial popped up today. I have no idea about it, and it's uh a former professor. Okay, uh, let's see. Did I put the link there? No, I didn't. Watch this. Boom. This should be the trial that's we're waiting on here, and this is only about 30 minutes or so. It's Tennessee Court of Appeals. Oh, I did. Boy, I tell you what, I am slow this morning. This morning's afternoon. This is what happens when you stream too late on things. Anyway, yeah, this guy he's a real good guy. He it's his third wife. He's accused of beating and kidnapping and uh yeah, a bunch of stuff. Real bad. Aggravated kidnapping, assault, interference with emergency calls, and domestic assault. Um, while their 3 month old son was in the home. Wow, the victim was able to send an email to her sister in South Carolina, who contacted the Knox County authorities to intervene. He confined her in the laundry room of the home, and he lectured her about not being a good wife. The attack continued in the living room when prosecutors said Edwards took his wife's cell phones, pointed a gun to her head, and asked if she wanted their son to grow up without a mother. So yeah, this is a professor. Higher education's great. Higher education's great. So yeah, this is a so I have to apologize. I started this stream because it was funny. I got up and saw the court was on. I turned it over. They're in Knoxville today, guys. I if you know, you guys should really find someone better to listen to because you'd think that I would go to the Supreme Court and see if I could stream from it. But anyway, yeah, that's this is and again this is the third time. Did you let's see where was the oh, when they arrested him, his wife had bruises on her face, arms, legs, torso, and groin, as well as a fractured rib. Prosecutors said they argued for an enhanced sentence based on Edwards' past criminal behavior, saying two of his ex-wives testified that he assaulted them during the course of their marriage. So this is a let's see, the violence included beating one of the ex-wives with a belt, burning one with an iron, and holding his second wife's head under water. Ladies, please don't. And this goes for guys too. Please don't be with somebody abusive. I mean, come on. That's the boogeyman's everywhere, y'all. The boogeyman is everywhere. You know what's funny is that you can do that pretty easily. Oh, but hey, you know what, Wendy? If you credit check me, I have a stolen identity. Yeah, so you be getting actually if you background check me too, yeah, you'd be getting a lot of oh geez. Guys, protect your identities. Okay? Please protect your identities. All right, come on, Supreme Court. So the Supreme Court says due to internet issues in Knoxville, streaming may be interrupted. We apologize for this inconvenience. Wow. They were working earlier. Well, we'll see what's happening. So I have to apologize. I started this. I thought this was um, a murder case because the same name. Ready for this? William Edwards pops up. And I typed in Tennessee too, is what gets me. But it's Jackson, Mississippi. I'm going to go ahead and read this since we got nothing else to talk to you guys about. So this happened in Jackson, Mississippi. In the 14 months that William Polo Edwards had been incarcerated at the Rankin County Detention Center for murder, he called the state's key witness more than 600 times. The woman, Shadow Robinson, will likely be the most powerful witness in the state's case against Edwards, charged with first-degree murder for killing 45-year-old Robert Davis in May of last year. The defendant is reaching out to a witness, the main witness, eyewitness in the case, and speaking to her about the case. And I believe of those calls, approximately 669 of them are the defendant calling the witness from jail. Testimony had revealed Robinson might have had a relationship with both men. Oh, that's why she's an eyewitness. It's unclear what the nature of the calls were at this point because they're coming through more than 1,000 calls and hundreds of texts obtained from the detention center. You can text from the detention center? Argue that those calls should be admissible because the investigator first handed them over Tuesday, 6 days before the trial. Oh, should not be admissible. Circuit Judge Faye Peterson said the information first made public Wednesday during a pretrial hearing will not be introduced as a whole in Edwards' murder trial because the jury trial itself will begin in the next 5 days. She did, however, reserve the right to consider individual calls if they were presented by the state. So, police went to the scene of the homicide. They searched the residence where the homicide occurred. They found some marijuana residue. They found 9mm ammunition. And bullets were used to shoot the man they found. A ski mask and a credit card and social security card of some other individual or individuals and multiple iPhones in Mrs. Robinson's home. I mean, you know how many movies are like that where it's like somebody is like a Black Widow type character, right? And they have all the collection of all these people's IDs and everything. Zach, what's happening? Um, how you doing, bud? Is your last name really Sotomayor? That's awesome. Um, anyway, yeah, that's not this case, but that was the case. That was the original case that popped up when I looked up uh, William Edwards. Oh, hey, well, this gets better. This gets better. Listen to this. Before his arrest, Edwards was perhaps best known for his work as a radio and Facebook personality known as Polo and the Cipher. He specialized in tearing others down, particularly those in public office. On Wednesday, many of those he targeted include former Hinds County District 2 Supervisor David Archie, who sat silent during the pretrial hearing. When was this? This was last August in Mississippi. Oh, that's so crazy. All right, let me see if I can find more about this trial, this professor. But man, the court's usually not this late. I bet you their internet's down. No, it's still loading you on their website. Oh wow. Okay, I'll have to check that out later. That's a cool one. All right, let's see. Former prostitute. Let's see here. Explore further. Boy, Edwards is not a good name to have in Tennessee. There's a Lisa Edwards that passed away. I like that it continues to say a former Knoxville professor, but it doesn't say where he's a professor at. All right, so this is the same story, different page. I cannot believe this is not working. I did not watch Little House on the Prairie. Christine, how are you doing? Mommy Spice, how are you? Rabbit, what's happening? Well, I'll tell you what. I thought this would be fun, and it's not. Holy cow, man! Let me reload this. Maybe that'll help. I mean, like how that's going to help internet problems over there. Well, that's no good. We have no court in Tennessee. That's awesome. Well, we can sit around here. We can check out what the Maricopa County. Why do I know Maricopa County? Why does that sound so familiar? Oh, it's Arizona. Well, we can see what the Maricopa County sheriff is taking questions for, or we could watch the $2,500 Wilson airless basketball. What my shrimp? Hold on, what does this say? My shrimp reproduced for 4 years. This happened. What does that mean? That scares me. I don't want to know about that. Well, guys, it looks like the Tennessee court is having issues. Yeah. Supposed to have another one. David Crawford versus State of Tennessee. Oh, look, this one came on. I don't know who David Crawford is.
That the trial court was in error when they denied Mr. Crawford the opportunity to even have a hearing on the motion. This court's aware, colorable claim.
Are you appointed on this case?
Did-
So it looks like they
Your
changed
Honor.
up who they saw
I just
next.
felt that there was an issue.
I apologize
I
for
wanted to
that.
help him on it. But Class X felonies do not exist anymore. Mr. Crawford is serving a life sentence in this present case. Life sentences are no longer possible for this type of crime. They're now A felonies. We're not necessarily looking to have Mr. Crawford resentenced. We just would like his judgment amended to reflect the current classification of a felony.
So you're retained?
Yes.
He has paid you to come before this court and submit a brief and argue?
Well, no, Your Honor. Technically, he just hired me to help him in trial court, and I'm here for free today.
Okay.
What?
My understanding of the rule is if you are hired at the trial court level, you're hired until you're permitted to withdraw by this court. So you are not here for free.
Okay.
Oh.
I just wanted to understand what your financial agreement with the
Oh.
defendant was.
He was hired as an indigent.
Well, it's our position
attorney.
that Mr. Crawford prevented
Hey, Aaron.
from him having a hearing. Rule 36-1
Thank you,
is
Miami.
to be construed liberally. We think Mr. Crawford's claim is colorable.
What
And
is it? What is the culpable claim?
The colorable claim is that, but when we did some research in his cases, or his case, that Class X felons that are still currently serving sentences, we found people that were serving a term of years. We weren't able to find anybody that was a Class X offender serving a life sentence. We felt that that differentiated him from other people. And I felt like I didn't see anywhere in the case law where that issue had been argued before. And
What case law?
I just did research on cases where people had been sentenced as Class X offenders.
Is that included in your brief?
No, Your Honor. My
Did you-
limited issue before this court,
I'm sorry?
my limited issue before this court is I thought the appropriate remedy at the time was to ask, it was brought up in, I believe, in my trial court brief, but for my brief here, I was just asking for him to have the opportunity to be heard on the matter in the trial court. And he wasn't able to get a hearing in the trial court, and therefore I've come to this court to ask them to give him a hearing in the trial court.
Well, summary dismissal is permitted by statute, correct?
Under certain circumstances, yes.
And what circumstances are that? Did you include that in your brief?
No, Your Honor, I did not.
So you didn't outline what circumstances you think were appropriate in this case?
I did not outline that. There were some things that the Attorney General did outline in her brief as appropriate.
And why didn't you include it in yours?
At the time that I filed this particular brief, I was not aware of those issues.
Okay, we gave you another opportunity to include those issues in your brief.
Right.
There is
I
no
just
way
didn't have
this
time
could be
to
the
get that part
same
corrected.
Earl Crawford.
You didn't really change your brief in any way, did you?
What I changed was I thought there was just.
This is
technical
challenging a
issues in it that y'all
1986
wanted me to
conviction
fix
of
some
aggravated
the
rape,
parameters in
kidnapping,
there, and
We
that's
were
what
very
and
specific
robbery.
in our order.
Well, Your Honor, I'm sorry if you felt like my amended brief did not comply with your order.
So what do you think that we should do? Because the state puts you on notice of the deficiencies in your brief.
Travis Bulls, how you doing, bud?
File a reply brief after the state puts you on notice of not only the
We gotta get together, man.
formatting deficiencies of your brief, but the substantive deficiencies in your brief. Both of those things were problematic, and you were put on notice. Then we put you on notice of those deficiencies, and you still didn't provide us or comply with the rules of this court.
I can see where that's a problem, Your Honor. I would just request that y'all consider our request and then, I guess, rule appropriately.
What is your practice? What practice area do you have?
I do criminal defense,
How long have you done criminal defense?
10 years. This is my first foray into the appellate courts.
Oh, she's like, what do we do? What do we do?
Have you had a discussion with your client about our last order?
No, Your Honor.
Have you had a discussion with your client about the
Thank you, Gamer.
the state, I guess, the state of your brief and the state's brief?
I've had various conversations with my client about how I'd really rather not get into conversations.
I don't need specifics. I just want to know if you've had, conversations.
I've had conversations with my client about the difficulties.
Have you
of this
even
case.
talked to your client?
Okay, and I guess the courts, or this court's order requiring you to amend or supplement the brief that you submitted, you had conversations with your client about that?
I do not want to get into specific conversations with my client.
I didn't ask you to, I asked, had you?
Did I speak to him about the particular order y'all sent?
Does he know you're here
No.
today?
Does your client know that this court has said the brief that you submitted was woefully deficient?
No, Your Honor.
When you received our order to supplement or rebrief, basically, your position, did you read Rule 27 of the appellate procedure?
Yes, Your Honor. And
So why did you not comply with that? And
I thought I had, Your Honor.
what did you add to that second brief?
I thought there was issues the way things were cited within in the brief, how I didn't necessarily have the proper table of authorities and tell you which page it was on, and that there was a lack of footnotes, which I added.
It's on their website. The rules are.
And, there was certain personal issues I was dealing with that made it difficult for me to create a brand-new whole brief prior to the deadline that was set by this court.
This case has been continued multiple times, counsel, multiple times. And we also gave you at least 2 weeks prior to this argument to.
I didn't think I was allowed to file anything else after that deadline that was set in y'all's order.
Well, that deadline was only, I don't know, last week. So you just put us in a very difficult position because your brief doesn't really comply with the rules, nor have you put the issue that you raise in any way such that we could actually rule on it, because we really don't know what you're arguing. You haven't really set that out in your brief. That's at a minimum what is required. We can't read your mind, counsel. So that's why I asked, how long have you been practicing?
Well, I'm sorry y'all feel that way.
Mr., is it Guerin? Is that how you pronounce it?
Yes, Your Honor.
Yeah. Let me give you just a little bit of practical advice that's been given to me several times and related to this court. We are basically an error-correcting court. A lot of lawyers have come up here who mostly do trial work and kind of present their case to us like we're, just like we're the trial court, only we might do something different than the trial court did. But we have to, if what we do is correct, if there are errors made at the trial court, and I don't mean to talk down to you, I just want to make it a little more clear that might help you in the future. If there are errors, then our job is, if they're harmful errors, our job is to correct those errors. So when I read
Well,
your brief, what I
here's the
read
thing.
was that
Hang on.
you believe that you did state a colorable claim in the trial court, but the trial court did not agree with you and dismissed your claim. But the problem, maybe this is too simplistic, but your brief, neither the initial brief or the second one, tells us why you think you have a colorable claim. It's just more basically, I have a colorable claim. And so we need to know a good bit more than that, is what it amounts to. And that's why, the issue with your brief is an issue at all. Now, the other advice I would give you, you said, how long did you say you've been practicing?
10, Your Honor.
Okay. And it's mostly in trial courts, I assume, because this is your first trip to the appellate court. So when I was practicing law about 10 years, there was no public defender, and we took appointed criminal cases because the judge told us to, and so we did. And then we, as Judge McMullen pointed out, we were on that case until it concluded at this level. So we had to go into the Court of Criminal Appeals from time to time. But if you have to go in front of this court even one time, it's really a good idea to get familiar with all the rules and everything that's required up here. If you have the luxury with the public defender taking most of the criminal cases these days, you might not have to appear at the appellate level in the criminal system. But if you do, it's really important to get your brief, filed the way it needs to be filed, so that we can, you obviously feel like there was an error here, and if there was, and we corrected it, it would be of great benefit to your client. But your pleadings, you can't just make up for it at oral argument. You can, you might be able to mitigate it, but you need to put it in your brief. Why there was an error and what the correction should be. So I hope what I've said has been helpful. I don't know, but
Yes, thank
it's
you.
what I've got to say about it. So
Can you give us any reason why this appeal should not be dismissed?
Yeah. You can't bring up stuff outside of.
I just think maybe in the interest of justice,
Oh,
I think Mr. Crawford's
What are the
particular,
interests of justice?
well, Mr. Crawford's serving a life sentence, and it's no longer possible under the current statutory scheme to get a life sentence for this type of offense. And
that doesn't matter.
I don't know, this is kind of a last resort thing for Mr. Crawford, basically.
No, he has to
To try and
petition
have the
the
opportunity to have his
governor.
sentence changed to where it's, well, I don't want to say change the sentence, just to remove the Class X classification. His judgments, which are on the record, already show that it has a release eligibility date of 35%, but the sentence is life, which is not applicable under the current sentencing scheme. So he was arraigned to offender at the time of sentence, but it doesn't make sense to give somebody a release eligibility date of 35% on a life sentence. We would just like that the Class
Well, then you had to
X
show that there's an error in the trial court.
be removed and converted to the current Class A as it should be.
And none of that is in the brief.
Well, I agree with you, Your Honor, but that's why I felt like it was appropriate to argue that before the trial court, and the trial court
What's that
denied me the
called?
opportunity to make those arguments. And that's why I came to this court to say, please order the trial court to allow me to make the argument. I felt like those particular issues weren't maybe
Gosh, I
wrong,
can't
we
remember.
weren't ripe
Caitlin, how are you doing?
that particular issue wasn't right for appeal. I thought the denial of the hearing was more an appropriate thing to appeal, not the, I just felt like, I don't know, if I denied the opportunity of, if I appealed the denial of a hearing, then if I was able to get an actual hearing in front of the trial judge, my client might have a better outcome.
Okay. Mr. Urin, I would join Judge Wiedemeyer in giving you advice in terms of how you approach the appellate courts. If you decide to come back or represent another individual before this court, I encourage you to familiarize yourself with the rules in terms of how to format your brief and what is required for a brief and for an issue not to be waived, and for, based on a combination of those two things, why an appeal could withstand waiver and dismissal. I strongly encourage you to review the order that this court dropped in this case and all the rules that we cited
Sorry,
in that
Caitlin.
order before you come back, before you decide
What's
to
up, Greedy?
represent another individual before the appellate courts.
Okay, thank you.
Wow,
General,
man.
Good afternoon.
Good afternoon, Your Honors. Abigail Renard for the state. This court should affirm the summary dismissal of the Rule 36.1 motion. For reasons already discussed, the petitioner's claim is waived. But even if it were not, he failed to state a colorable claim for relief and was not entitled to a hearing.
There you go.
Here, to the extent that I understand the petitioner's arguments, he's claiming that the criminal savings statute should have applied to get rid of the Class X designation. But the petitioner was convicted and sentenced in 1986, and those convictions were affirmed on direct appeal in 87. The Class X felony designation was not repealed until 1989, well after those convictions became final. This court and the Tennessee Supreme Court have repeatedly held that the criminal savings statute would not apply in those situations.
It's true.
So if this court has no questions, we ask that you affirm the dismissal. Thank you.
All right, to go back to what I was saying to counsel, you're saying that that when the trial court denied the hearing that he's requesting, it was not error,
Correct.
okay?
Yes.
And the reason it was not error was because there, in fact, was not a colorable claim stated to the trial court that he or she should act on and have a hearing about.
Yes, Your Honor.
Is that correct?
That is correct.
Okay, so without regard to briefing, the essence of this whole case boils down to the state's position. His position is he should have gotten a hearing. It was error not to, and your
Yes.
position is there was no error. Therefore, this court has nothing to do. I mean, there's no relief to be granted.
Correct, Your Honor.
Okay. Thank you, General.
Thank you.
That guy's really good.
All right, any rebuttal or?
So he just explained the,
You've heard my argument.
All right.
I don't have any to rebut. Thank you.
All right. Thank
Yeah,
you, sir. Call the next
you
case,
stand up and
please.
say, no, sir, and leave quickly. Don't even worry about getting your parking. No,
What's
no,
poppin',
I don't know what
Vampire
this
Hunters?
is.
It's-
Stop that. Oh, this is not. Oh. No, we don't want David Crawford. All right, here we go. This is the one we started with. This is the one with the professor. Oh my gosh, that guy doesn't even need to get his.
Is this Mr. Cavanis? Yes, sir. All right, sir. Good to see you.
Parking validated. He just needs to leave. I bet you I can find a bar he's gonna be in tonight. Tonight. What time is it? 2:00? He's going straight to the BG right now. I bet you anything.
Is the court
You may
ready?
proceed.
All right, thank you, sir. May it please the court, my name is Tyler Cavanis of the Knoxville Bar. I represent the petitioner appellant, J. William Edwards, and with the court's permission, I'd like to reserve 3 minutes for rebuttal, please.
Certainly.
Thank you, Your Honor.
This guy thinks he's good.
3 minutes?
3 minutes, yes, sir. Your Honors, Mr. Edwards' case, in this posture on appeal, I'm going to be focusing really on what I perceive to be deficiencies in the post-convictions court, I should say shortcomings in the post-conviction court's order on the
Deficiencies are
post-conviction hearing.
shortcomings.
With respect to the issues we've raised, I believe that this court is in a position where remand is necessary because there are not adequate factual findings or legal conclusions related to the claims that were raised in the post-conviction petitions and also raised at the hearing. And that really comes down to two categories of claims in this case. The first is that trial counsel, I should say it this way. The first relates to Mr. Edwards'
That's the second
knowing
time
and
you should say it this
voluntary
way.
waiver of his right to testify, or the fact that it was not knowing and voluntary. That was raised in two ways before the post-conviction court. It was raised both as a standalone claim that the requirements of Moman versus State were not met, that there was not an adequate Moman hearing to establish a knowing and voluntary waiver from the record, and as a result, that claim in and of itself is a constitutional violation that would require relief. Secondary to that, Mr. Edwards raised that trial counsel was ineffective in not requiring a sufficient hearing to be held, and also not allowing Mr. Edwards the right to, or the opportunity to testify on his own behalf. And then the second category of claims relates to a deficiency in the indictment and the jury instructions that were given at the conclusion of trial. I'll focus on the jury instruction issue first because I believe that that's the category where the post-conviction court's
Incompetency of counsel is
findings
always
were,
raised in appeal.
as opposed to most minimal. The issue in Dr. Edwards' case was that he was charged, relevant to this appeal, he was charged with
Right?
count 1, especially aggravated kidnapping, count 2, especially aggravated kidnapping. Excuse me if I can grab my note or look at my notepad. Count 1 was especially aggravated kidnapping with a deadly weapon. Count 2 was especially aggravated kidnapping with serious bodily injury, just alternate theories of the same offense. And then count 3 was aggravated kidnapping as a standalone count, alleging that the victim suffered serious bodily injury. But the way that the trial court instructed the jury was that on the same page, counts 1 and counts 2 were, the elements of counts 1 and counts 2 were laid out. Count 1 being the complete elements of especially aggravated kidnapping with a deadly weapon, count 2 being especially aggravated kidnapping when the victim suffered serious bodily injury. As a lesser included offense, on the following page, aggravated kidnapping was laid out to the jury. However, the instruction the jury received as to counts 1 and 2 and the lesser included version of aggravated kidnapping was only the element of serious bodily injury, not possession of a weapon during the commission of the kidnapping.
Wasn't these issues that you're arguing, weren't they addressed on the direct appeal?
They were, Your Honor, and I believe, I should say that from a strictly the application of the law to the record, they were, but not in the context of trial counsel's deficiency in failing to object to those issues. And on this appeal and at the post-conviction hearing, I believe the framework for that issue is that, or the error and then the prejudice resulting from that error is that this court on direct appeal reviewed those errors, or reviewed the indictment issues for plain error. And so, for example, with count 3, which was the standalone count of aggravated kidnapping, this court in fact found that there was a constructive amendment to that count because it alleged both versions of aggravated kidnapping, even though it was only charged one way in the indictment. And so, of course, this court found that the jury was then permitted to convict Mr. or Dr. Edwards on a theory that was not alleged in the indictment. But under a plain error review, this court's ruling was, although there was a clear and unequivocal breach of the law, the court could not find that there was that the error necessarily impacted the outcome of the trial because the jury did have the elements of each offense, and the court on appeal under plain error review couldn't say for sure that the jury looked at the wrong set of elements in reaching or in convicting Dr. Edwards. And so I believe that the way that the issue was before the post-conviction court and is now before this court
You're
is
arguing
that
with yourself.
had trial counsel objected to the error in the indictment, or rather the error in the jury instructions, this court would have reviewed that error under a de novo standard, or that issue under a de novo standard on direct appeal. And at least as to the constructive amendment, I believe this court's law is clear that a constructive amendment is automatically requires reversal under de novo review. And so had trial counsel, so the argument on post-conviction is that trial counsel was deficient in failing to object to that error in the instructions. The failure to object to that error resulted in a plain error standard of review. Had that not happened, Dr. Edwards would have been entitled to relief at the very least as to count 3. This court very well, I believe it's likely this court on direct appeal would have reversed that conviction.
Oh, that's for
due to
rebuttal.
the
3 minutes
constructive
for
amendment
rebuttal.
of the indictment. But as to counts 1 and 2, the argument would have been that there was an improper instruction of the law based on
Aggravated kidnapping
essentially just the
includes
confusing
using
way
a
that
weapon.
these elements were laid out. The jury,
He's saying that
within
he did
3
commit
different
the crime,
counts, received
but
3
they
different
charged him
sets of
whether the
elements
jury
for
instructions
aggravated
were
kidnapping, and there was
were
no
not
really there
to
was
the
no
T
clear
correct.
instruction on how that should be
Saying
applied
that'd be
to the
different
various
if the
counts of
trial
conviction.
had
But
objected,
again, because trial
because
counsel
both
failed
elements
to,
were in there,
to object
but
to
they
those
don't know
errors
which
at
ones the trial,
this court was
the
confined
jury
to a
looked
plain
at.
error review, and that's the resulting prejudice to Dr. Edwards. And so I believe
prejudice.
that's the argument that I
Good use of
presented
the
to the
word.
post-conviction court, and I believe that the reason remand is necessary at this point is because the post-conviction court's findings were really limited just to one page. On the first page of the post-conviction court's order, it set forth the 4 claims that it perceived Dr. Edwards to be raising in that hearing, and then it said that related to the indictment issues, those had previously been litigated on direct appeal, and the post-conviction court, in essence, would not disturb those findings. But the distinction I'm making is that, yes, they were ruled upon on direct appeal, but not with an analysis of whether trial counsel was deficient in addressing that issue and what the outcome of that deficiency could have been. And the post-conviction court here really just didn't make any findings. In fact, it fairly straightforwardly said this court will not be addressing those claims because they were already raised on direct appeal. And so I believe,
So I just want to make sure I'm clear. No ineffective assistance of counsel findings of fact were made by the post-conviction court as to this issue?
I'm sorry, Your Honor, I wouldn't say that. I would agree with the state here that the trial court did make credibility determinations about Dr. Edwards' trial counsel. Both of them testified at the post-conviction hearing. But I would say that because the trial court at the outset of its order explicitly said that it would not be addressing the claims related to the indictment issue and the jury instruction issue, none of those findings of fact, there was no conclusion of law related to those issues in the post-conviction court's order. And so I would say that the findings of fact really did not apply to that issue because the court just at the outset of the order said it would not be addressing them. But I do agree with the state that there were findings of fact made related to the moment issue and Dr. Edwards' opportunity to testify.
And with regard to the moment issue, the post-conviction court here said that, are you saying that, well, first, I guess I have 2 questions. Are you raising a standalone challenge in post-conviction, and is that what you raised before the post-conviction court?
Yes, Your Honor, I am raising,
You raised both?
I'm raising both. Both that, so in the amended post-conviction petition, the first amended, and I could provide the court with the citation after I sit down, we did raise that trial counsel was ineffective in not permitting Dr. Edwards to testify, right? I can't remember the exact language we used, but related to the failure his
You don't
lack
want
of
your
opportunity to testify.
client to testify.
But in the second amended petition, and certainly in the argument at the hearing, and relying on both Momen but also Breer versus State, we are raising a standalone claim, or I am raising a standalone claim. And I know that the state has argued waiver related to that claim. And I guess as an initial matter, I would say that the state has waived its waiver argument. The state.
Waive its waiver argument when you didn't raise it. I never really understood how that would work. How is the state supposed to waive an argument when it's not addressed below? I guess I don't know how that works. It's kind of circular.
Well, and I think perhaps I misunderstood or didn't
think
answer
it's
your question.
circular. I love
My
this
position
guy.
is that I have raised a standalone Momen claim.
You raised it below,
Yes.
and you raised it on direct.
No, not on direct appeal, Your Honor. And so to then take a step back, my position is that the state has waived the claim that its claim that my issue is waived for failing to
Waiver, yeah.
I'm trying to not use too many
circular.
negatives. I agree. The Momen claim, the standalone Momen claim was not raised on direct appeal. The state argues that results in a waiver in the post-conviction proceedings. I believe the state has waived that argument now because it did not make that objection before the post-conviction court. And so I think that the state is not permitted to argue the waiver.
Does it matter whether the state raised it when the PC court could not have considered it to begin with?
I think it does, Your Honor, and I think the conflict I believe there is a conflict in the law, or at least an uncertainty in the law. I agree with the state. The state has presented this court with authority, unreported cases as far as I've seen from panels of this court that do say that this is a claim that must be litigated on direct appeal. I agree with that. But then Momen itself is a reported case from the Tennessee Supreme Court, of course, that is a post-conviction case and examines this standalone constitutional claim without any reference to whether it was raised on direct appeal or not. And in fact, all of the language that Momen uses talks about the fact and establishes the fact that the failure to establish a knowing and voluntary waiver is of a constitutional dimension and of a fundamental constitutional dimension. And so I've also cited in my brief Breer versus State. That is an unreported case also from 2005, which was a year
won't let
after
his wife
one of the
leave
2004
as he
cases the
beat her.
state cited. And in that case, there was no analysis.
For
It
however
more
long.
closely followed Momen in the sense that there was not a proper Momen hearing, and the court really looked at that as an issue of if there wasn't a proper Momen hearing or the record doesn't support a proper Momen hearing, this is a standalone constitutional violation. And in the post-conviction context on appeal, reversed as a result of that. And so I recognize, and I think my position would be that there is some inconsistency or some conflict between cases from this court, but I think that Momen's the fact that wasn't an issue brought up in Momen at all, and that is in a post-conviction appellate context, I think that controls on this issue. My position would be that controls on this issue. And so getting back to your question, Your Honor, could the post-conviction court have raised it or even addressed this in the first place? I think it could have. I think that the state should have objected to this at the post-conviction court, and we could have litigated waiver at that point. And then just related to the standalone Momen issue, as I have laid it out before this court, I do think that if this court considers the standalone Momen issue, the record does not support that there was a knowing waiver, and I would characterize the hearing as not being a Momen hearing because the requirements of Momen were not met. The final factor of the record establishing that the defendant did in fact acknowledge the waiver of his right, that just didn't happen in this court, or in this case, excuse me. What happened was after the state concluded its proof, the trial court and trial counsel went through a Momen hearing on the record, or went through the stages of a Momen hearing on the record. They got to the question of Dr. Edwards' are you going to waive your right to testify? And the trial court said, well, we'll address this first thing in the morning. They get back to the next day of trial, and that hearing was never continued. There was never a finding on the record that,
But doesn't this ultimately become a fact question? Because what the post-conviction court did was basically weigh the credibility, assume basically that there was a conversation between defense counsel and the defendant, and that the conversation between defense counsel and the defendant resulted in the defendant not wanting to testify?
so I would agree with that in the context of the IAC analysis. My argument would be that if a standalone Momen claim is properly before the court, then the legal question is, what does Momen require? Does Momen require that all of those four things specifically enumerated by the Tennessee Supreme Court, do those have to be on the record, or is 3 enough and we'll assume? I really think that, I think that the argument on the standalone Momen claim is purely legal in terms of what does Momen require. And certainly then if there was a determination that substantial compliance was sufficient, then yes, there is a factual analysis there.
So at the post-conviction hearing, did trial counsel testify? While we may have not covered it all
Awesome, I wish I
on
had
the
put it
record,
up.
he and I had this discussion, and he knew that he had the right to testify and the right not to testify. Because as I read the record of the Momen hearing, it sounds like he was clearly told, you cannot be forced to testify. That part was pretty well set out. What seems to be missing is the part that if you want to testify, nobody can stop you. And that seems to be what he's complaining about now, not being told that. But at the post-conviction hearing, his lawyer testified, if I recall correctly. Oh, yes, we had those discussions. Is that right?
I think that's a fair, overall, I think that's a fair characterization. I think
And then,
that,
I think what Judge McMullen was pointing out is that if the trial court says, I credit the testimony of trial counsel, does that cover all issues, ineffective assistance, whether or not the Momen discussion was had? That
I think that those findings, the way I see the distinction is if Momen requires there to be testimony on the record that the defendant is in fact waiving his right to testify, then that's not sufficient, because we don't have that here. We don't have that final question being asked of Dr. Edwards on the record. And as I've asserted in my brief and would say today, that's what Momen says. That's what Momen says those must be on the record, and that's a straightforward requirement. And so
it doesn't matter then the trial counsel testifies at a post-conviction hearing. Oh, we had those discussions off record, but we had them.
my position would be not under a standalone Momen claim. And so I have used my time, and
I'm going to get out of here. I used my time up.
Please.
Thank you.
Good afternoon, Your Honors. Abigail Renard for the state. This court should affirm the denial of post-conviction relief. First, the post-conviction court's findings are sufficient to facilitate appellate review here. And second, the petitioner waived his standalone Momen claim by failing to raise it in his motion for new trial or on direct appeal. And to the extent there was any error in the Momen colloquy, it was harmless. So first, addressing the findings. The findings here are sufficient to facilitate appellate review. Admittedly, they're not the best findings out there, but this court has concluded repeatedly that where a defendant cannot show plain error on direct appeal, he can also not establish prejudice in the ineffective assistance of counsel context.
I'm sorry, when you said admittedly the findings were not the best in the world, that's what I heard when it got to me.
Correct.
Is that
Yes.
right? So,
Yes.
you're talking about the post-conviction court's order regarding petition for post-conviction relief, that order?
Yes, specifically the findings related to the indictment issue and the jury instruction issue. The rest of the order, I would argue, is very sufficient and thorough factual findings and conclusions of law, but that, as it relates to those two distinct issues.
And could you clarify that for us? Because in this case, was the trial court confused about its duty Or can we tell that?
It's not clear, Your Honor. Perhaps it was confused. It seemed concerned with potentially contradicting something that this court had already relied on. Certainly,
Well,
we
that's
would
not
agree
good.
that ineffective assistance claims are obviously different from the direct appeal claims. So perhaps the trial court was confused. It's not clear entirely what happened there or why the court's findings are as they are. But we would argue that even though they're, not ideal, they are sufficient for appellate review here because there's no real factual dispute about what happened. So as it relates to the indictment jury
Yeah.
instruction issues, there's no dispute here that the attorneys didn't object. This court found a violation of a clear and unequivocal rule of law, and whether that is deficient performance or not doesn't necessarily affect the outcome of this case because the petitioner cannot show prejudice, because this court found that although there was error, substantial justice was not at stake because it was not so significant that it would have changed the outcome of the trial.
And
So
that
even
was,
if-
that was a finding of the direct appeal.
That was on direct appeal, yes.
And so your argument is because a panel of this court made that finding, then that's going to overcome any prejudice argument that the defendant may later have at a post-conviction hearing.
Correct. And this court has found that in several cases. And similarly with the jury instruction issue with the white instructions, it's the same kind of issue where this court analyzed it for plain error and did not find plain error. And so because the petitioner cannot establish plain error in either of these issues, he cannot establish
Speak
prejudice.
to his claim that the review under the differing standards of review is in and of itself the prejudice. That's what I took from his argument. Does that make sense?
Yes, so I think I think there's a difference though, because the claim would have been dealt with at the trial court potentially. I don't think we can assume that just because the petitioner didn't object then, that it would have been overturned on direct appeal and he would have gotten a new trial. I don't think that's what necessarily would have happened. I think he would have brought it up and the trial court would have said, oh yeah, there's an issue, or could have said there's an issue, and they would have fixed it then and there. I don't think
Yes,
it would
they would have.
necessarily have resulted in a new trial or a different outcome, which is why ultimately I think this court found that there was no plain error.
That's what I was
and
saying earlier
found that
about
the issue was not so significant
jury
that it would have changed the
instructions.
outcome of the trial. And if
Yes,
turning
Court of Criminal
briefly to
Appeals.
the
It's a
moment issue
Knoxville
as well,
case.
again, we would argue that the petitioner waived his moment claim. It's a standalone claim. He did not bring it up in his motion for new trial or on direct appeal. But even were it not waived, the court here in these findings did pretty much exactly what it's supposed to do under the circumstances. And it actually found that there was a moment violation here because based on the record, it's not clear that the petitioner personally
And remember,
waived his
people,
right
they're
on the
admitting that
record.
the guy
But those requirements of
beat,
moment and those
punched,
procedures are not
kicked his
constitutionally
wife,
required.
broke a rib.
And so the court has then proceeded to conduct the
Wouldn't
harmless
let her
error
leave.
analysis that it should have. And it analyzed all of the 4 factors that are outlined in Momen. It discussed the importance of the defendant's testimony to the case, the cumulative nature of the testimony, and both of those it seemed to weigh a little bit less, but particularly important, it found that the presence and absence of evidence corroborating or contradicting the defendant. Here, the defendant would have claimed that the victim was lying, that the photos of her had been doctored, that she put on makeup to fake her injuries, and that she broke her own rib. And all of that would have been directly contradicted by the victim's testimony and by a lot of the evidence in the case that was corroborating her testimony. And the post-conviction court found that there was overwhelming evidence supporting the state's case here and concluded reasonably that any error here was harmless.
Is it the state's position that a moment problem or issue cannot be raised in a post-conviction claim unless it has been addressed in the direct appeal.
It could have been raised in the context of ineffective assistance of counsel, but as a direct standalone claim,
And that's, I
That
guess,
is-
what I mean, a
yes.
standalone claim. It's going to have to be raised in the direct appeal.
correct. But,
Okay.
yes. And if this court has no further questions, we would ask that you affirm. Thank you, Your Honor.
Thank you. Rebuttal?
Thank you, Your Honor. To briefly address the, I guess, assumption that had trial counsel related to the standard of review of the indictment and the jury instruction issue, had trial counsel objected at trial, I agree. One possibility is the trial court would have realized the error and fixed the jury instructions. But it's also possible that the judge would have disagreed that there was an error, the error would have been properly preserved, and that constructive amendment would have then still proceeded to this court for review of that error. And it would have, the constructive amendment in particular would have been an automatic reversal under this court's law. And so I certainly, I recognize what the state is saying there, but I think that the assumption that that error would have been fixed if there had simply been an objection lodged, I believe that's too speculative.
I think we're still getting, we're trying to conflate two things, and that's what's confusing everyone, because again, she came back with, and you can't ignore the fact that the prejudice, you look at the entirety of the case and the entirety of the evidence, and ultimately, on direct appeal, we said the overwhelming amount of, proof in this case didn't require reversal. I understand what you're saying, that we have cases that say basically, hey, when this happens, it needs to be reversed. But again, I think we're conflating the two standards and the two contexts between direct and post-conviction, and that's what's causing a lot of consternation.
And as I think about that, I recognize the similarity between the prong under plain error review, that it would have likely changed the outcome of the trial, that very similar to ineffective assistance Strickland. But really what I'm saying here is not that it would have likely changed the outcome of the trial, it likely would have changed the outcome of that conviction on appeal because of the change in review. And I recognize what you're saying, Your Honor, about conflating those standards, but I don't think that Dr. Edwards, there must be something there, because it was trial counsel, my position is it was trial counsel's error that resulted in the harsher standard that then resulted in this court upholding his conviction. And so if this court finding that plain error didn't apply in that context, this is kind of a different type of error where I think we're generally on the same page that under a de novo review, that was an error requiring at least reversal of that count. We can attribute that error now on post-conviction to trial counsel's failure to object, to put it before the court, to change the standard of proof. And truth is, Your Honor, I agree there's some there's tension there, but to then say that Dr. Edwards just has no remedy because this court already found plain error did not apply, doesn't seem fair, for lack of a better term. But I've used my time. Thank you, Your Honors.
Thank you,
This
sir.
guy's beaten 3 wives. Gosh, man.
Call the next case, please.
That's you guys see what I did. I don't have nothing to do with trials. Just go over and watch the Tennessee.
Did you come in and out of the DA's office?
Well, that's not what I wanted to
And so
happen.
were you able to witness Mr. Wade and Ms. Willis interact during that time?
I'm going to object. This has been asked and answered. It was addressed.
Nope. Well, I'm on Instagram. I don't want to be on Instagram. Well, that's all bad. So that sucked. What happened? Hang on, how did that jump off like that? 10 courts. Why is that one not streaming? Hang on a second here. Let me pull you guys back up so you can see what's happening. Yeah, all these are right now. Eleven 45. Yeah, this is supposed to be happening right now. Well, anyway. Let's see here. Wait, so what's happening? You talking to me? I got a haircut. I don't know the Danny Masterson case. Oh, you're talking about the one. I know you're talking about. Oh, hang on.
Aware that the bullet was actually in the chamber and that he failed to faithfully execute his job of informing her, hey, don't pull the trigger this time.
What?
As I understand that.
Well, we
this
ain't even
theory
halfway
of,
through this. You guys saw it. I had
Russian
it up.
roulette, he knew the bullet was in the chamber and he kept quiet. That is what the state has now asserted was the basis of Mr. Birkbile's conviction. I assert there's two problems with that. The simpler problem is that's not what the state said at trial. The state said a lot of things at trial, different versions of why Mr. Birkbile was guilty, an opening statement and closing argument, a rebuttal closing argument. But this, he knew and he kept quiet theory, I don't believe can be found in the trial transcript. The other problem, equally important, is the proof doesn't support that theory. In the sense, and this is a spectacularly complicated case to boil down to sort of just on this issue, Hornbook application of sufficiency analysis. You can't have sufficient evidence for a criminal offense if it's based on conjecture, guess, speculation, or a mere possibility. It's our position, the state's argument that he knew the bullet was in the chamber and he kept quiet and he shouldn't have and she pulled the trigger, that's a mere possibility. It could have happened. I can't rule it out. But it also could have happened many, many other ways. As we've talked about in our brief, this is conduct that they engaged in that is clear that they did it from the record, but it's not clear what they were doing in the record. This is also a situation where this happened on a day which she had been told by her live-in boyfriend that she was to discontinue the relationship with Mr. Birkbile, that she was also told by Mr. Birkbile that he was not going to be able to visit her, as they had both been looking forward to. So you have a multitude of possibilities of what led up to the moment where she pulled the trigger. The state has picked one and has put its eggs in that basket.
Guys, this is amazing.
It's our assertion that that choice, based on this record, is
Check
sheer
out what
speculation.
the background is on
and
this.
so, for that issue, even if maybe the state's theory somehow answers the probable cause argument, it is a theory that does not have a sufficient factual basis. And the flip side of that is those other theories that I did try to address in my opening brief and point out why proximate cause wasn't available for those either. The state has waived reliance on those by not presenting them to this court. To move to my second issue.
This guy looks like Dana Carvey
and
playing
that is
Darth.
the speech alone issue. And I think it's important for this issue to understand something a little bit different in that criminally negligent homicide, I guess we don't have common law crimes. But if there's something that's as close to a common law crime, that's what criminally negligent homicide is. You have a very basic statute saying criminally negligent homicide is, homicide that's done after a criminally negligent
The
act.
homicide here
and then you have
is-
a world of interpretive law setting out.
He talked the girl into
the,
playing Russian roulette over the
what
internet.
that means. So proximate cause, so independent intervening act, all of those things are developments by the courts interpreting
That's it.
a very basic criminally negligent homicide statute. It's our assertion that although I don't think this has ever had to been dealt with by the courts of Tennessee before, criminally negligent homicide also has to have an exception. The statute does not cover constitutionally protected speech alone. And so the basis of this argument, we're not saying that the statute properly interpreted violates the First Amendment. We're saying the statute properly interpreted incorporates the First Amendment. And the First Amendment, as I've tried to set out in the brief, says you can't criminalize, you can't punish speech alone other than in a few very narrow exceptions. Excitement to imminent lawless action, fraud, true threats, speech that is an integral part of criminal conduct. The twist to this, and this is something that I commend to the court, the decision of the Minnesota Supreme Court in a case called Melchert-Dinkel. The twist to this is that the linchpin of the analysis of the Supreme Court of the United States in cases like Gaboni versus Empire Storage, the linchpin of a lot of these has to do with you can't incite unlawful activity. You
his First
can't
Amendment claim he's
use
making.
speech as part of unlawful activity. The twist is, however unfortunate, unhappy, tragic suicide is, our legislature has not actually said that's criminal. That gives us a situation where even if the state were to prove that someone like Mr. Birkbeil had directly encouraged, suggested, advocated for someone to kill themselves, if all they have done is engaged in speech, that is protected speech. And it's my argument that protected speech doesn't fall under the criminally negligent homicide statute.
So what type of speech is it that, we always heard in law school about you can't walk into a theater and scream fire? That's not protected under First Amendment, correct?
Actually, it is,
That's right.
as long as there is a fire.
Maybe I'm just not connecting on this.
You have
How
to-
is, when someone is
Intent of screaming fire. What is the intent
standing in
of
front
it?
of you or on a monitor and they have a weapon and you say, pull the trigger, how is that any different from walking into a theater and screaming fire? Maybe I'm missing something here.
And maybe I'm missing the explanation. The problem with walking into the theater and yelling fire is if there is no fire, right? Because it's false. And
there is.
so I guess that would perhaps
Or
bring it
every
under
actor
the
on
fraud
stage,
exception.
and part of the
You
play
can't-
says fire. They would be held.
Deceptive conduct maybe is not
Liable.
protected by the First Amendment, or conduct likely to lead to, a riot in the movie theater that is unnecessary. Here, I think we're just talking about the consequences of the legislature's failure to criminalize suicide. I would not have this argument if there was a statute saying that suicide was against the law. But what we have here is a question of, is our penal statute, criminally negligent homicide, is that going to cover a situation where through words alone, someone has encouraged, induced someone to do something that is, we all agree is bad, but is in fact not illegal. And the United States Supreme Court in Gaboni and all the other cases have talked about its imminent incitement to illegal activity. It is speech that is integral to criminal activity. And so that's why Minnesota Supreme Court said, however lamentable suicide is, if it's not illegal, then speaking by words alone, again, be different if Mr. Burkebile had given her a gun, had given her the bullet, had been there physically assisting in some way. We're talking here about speech alone. So it's our position that criminally negligent homicide under the doctrine of constitutional avoidance has to be interpreted. As I said, it's already kind of a common law crime. It has to be interpreted to not cover situations of speech alone when those instances of speech alone are constitutionally protected. And the final issue I want to talk about is the territorial jurisdiction issue. Obviously, Mr. Burkebile was in Indiana during this whole time period. I had not been in Tennessee, at least for weeks, if not months. And any contact was just electronic and or telephonic. It's not a case, not an issue that arises very often. There really is, as far as I could tell, only one really close analogy. That's the Audra Lynn Johnson case from this court in 2006. And what that panel did in that decision was correctly to look at 3911-103, kind of a weirdly written statute. But what this court said in Audra Lynn Johnson is that even if an offense is consummated in the state of Tennessee, which we concede a homicide offense is consummated where the person dies. Even if an offense is consummated in the state of Tennessee, there is a defense for a defendant who remains outside the state the entire time, unless the defendant has employed a guilty or innocent agent, or the defendant has employed other means proceeding directly from the person. So I think the state sort of agrees that we are here interpreting this phrase, one phrase, other means proceeding directly from the person. It's our position, it's my position, and essentially I think this is supported by a gloss of that phrase in the Audra Lynn Johnson case, is other means proceeding directly from the person refers to some kind of physical activity. So Audra Lynn Johnson talks about someone standing over the border in Kentucky and shooting into Tennessee. And we don't have that here. There was no gun wasn't sent by Mr. Burkebile. Bullets weren't sent. Nothing physically was done by him that passed into the state of Tennessee. And the other thing I want to say, and this is something that I think I did not do a good job in my reply brief of pointing out. It's in there. It's not made as forcefully as I think I should have. And that is, in the state's brief, at page 33, the state says, the key to territorial jurisdiction is the deliberate attempt to cause a crime to occur in Tennessee. And I think that answers the question here on these facts. Deliberate attempt to cause a crime to occur in Tennessee. The state didn't charge a deliberate attempt. They have not argued on appeal that there was a deliberate attempt. What they have argued is that there was a negligent failure to act. And if the state is conceding that you only get territorial jurisdiction if you have a deliberate attempt to cause a crime to occur in Tennessee, then on these facts, there clearly was not such. Even if the state's theory were accepted and found to be sufficient as a matter of establishing criminally negligent homicide, arguing that Mr. Birkbile remained silent at a time when he should have spoken up is not, that's not a deliberate
Dude,
attempt
what
to
did you
cause a
do?
crime to occur in
Like, what did
Tennessee.
he?
So,
What was the thing? What did he do
I
after this?
think,
Like, was he
I will
watching
reserve
this?
the
Was
rest of
it
my time
a
for rebuttal if there are
Zoom
no
call?
questions at this point. Thank you.
Thank you.
This is crazy. I didn't know about this. This is wild. But
Good afternoon, Your Honors, and may it please the court. My name is Garrett Ward. I'm here this afternoon on behalf of the state of Tennessee in the matter of State versus Hayden Birkebile. Your Honors, this court should affirm the defendant's convictions because the evidence was sufficient to support this conviction, and the state had territorial jurisdiction over this crime. As opposing counsel did, I will devote my time before this court to the sufficiency and territorial jurisdiction issues, and rest
no,
on my brief
she
for the
did
remaining,
it. He
for
told
the
her,
remaining issues.
yeah,
Although
load
I'm
the
happy
gun.
to answer
She
questions
did
should this
it.
court have them.
I mean,
Your Honors, turning to sufficiency, this case is, I hesitate to ever use the word unique in this field, but this case is at the very least unusual. It has sort of this combination of facts that I have not run across before in my time at the Attorney General's office. Many of these facts are salacious, and some of them are, frankly, disturbing. But at the core of this case, looking through the facts, our core legal inquiry here is
where do you
around one of
find
the more,
justice?
maybe the most fundamental legal concept, especially in
I'll be right back.
criminal and civil liability, criminal in this case,
Well, I'm
of
listening.
negligence. So our core inquiry here, despite the fact that these facts are so novel, our core inquiry here is a familiar one. It's, did the defendant, because this is criminal negligence, did the defendant sort of grossly depart from a standard of care resulting in the death of the victim, in this case, Ms. Sparks? Your Honors, as I understand the defendant's sufficiency challenge, it is largely in the proximate cause field, at least preliminarily. His initial challenge is in the field of proximate cause. And, Your Honors, although it is impossible in a 20-minute argument to fully convey the facts of this case, I believe at least a brief discussion of them is frankly necessary to understand proximate cause here. Your Honors, a large percentage of the proof in this case was roughly 10,000 Facebook Messenger messages exchanged between Mr. Birkbile and Ms. Sparks, the victim here. In these messages, as are most relevant to our inquiry here on appeal, because there were a great number of messages which were over, routine everyday topics like pets and work frustrations, things of that nature. But as relevant to this appeal, we glean a great deal about both their relationship and what happened on September 29th, which was the day that Ms. Sparks passed away. What I'll first start with is what we know about their relationship overall from these messages, because the nature of this relationship is really central to the negligence question. Your Honors, without passing any judgment or making any statement about this relationship, Ms. Sparks and Mr. Birkbile were engaged in a relationship of a sexual nature that depended at its root on Ms. Sparks engaging in forms of self-harm and pantomime suicide for the defendant's sexual excitement. That is crystal clear from the proof in this case. What's also clear is that to effectuate this odd relationship, on a number of occasions, the defendant encouraged the victim, and she agreed on these earlier occasions to engage in some sort of, I'll use the term game here as perhaps broadly as it can possibly be used, to engage in a game that resembled Russian roulette. What is clear from their discussions pre-September 29th is when she would engage in this game for the defendant's sexual gratification. Ms. Sparks was, to the extent one can be protected while playing Russian roulette, was protected because she was able to see which chamber of her gun was loaded, so she wouldn't actually claim her own life. That was, as astounding as it is, that's what the proof shows happened on multiple occasions in this case, which brings us to September 29th. On September 29th, there is a great deal of discussion about engaging in this sort of Russian roulette play again. Then there is a video call. That video call wasn't, I believe, was on Facebook Messenger, despite the fact that the logs were preserved. The video itself wasn't preserved. I haven't seen it. Mr. Harwell hasn't seen it. Nobody in this case has actually seen this video call. But what occurs during this video call is gun discharges, and Ms. Sparks dies. Now, Mr. Harwell, opposing counsel, has suggested that we don't actually know what happened on this call, and therefore, both we have failed to prove sort of proximate causation and just on a more baseline level, and failed to prove anything beyond speculation. And, Your Honors, I think a helpful way to view this issue is if this court were to regard the call as sort of the call itself as a play. We have the stage directions for it in their messages from September 29th. We know from their discussion on September 29th what was going to happen on this call, and I'll briefly run through those messages. Ms. Sparks offers to engage in this Russian roulette-style game. She offers to do that for Mr. Birkbeil. Mr. Birkbeil tells her that the game doesn't really work because she knows where the bullet is. Ms. Sparks responds, well, essentially, well, I can fix that. I could wear a blindfold or I could close my eyes. She goes on to say, and then you would know where the bullet is and I wouldn't. You'd get to decide whether I lived or died. Not me. You, Mr. Birkbeil, would get to decide that. Later on in their conversation, when Mr. Birkbeil asks her if the thought of dying excites her and she says no, she tells him that, and this is explicit in her text messages. She tells him that she trusts him to not actually allow her to die. That she trusts him to enjoy the trust and power she's granted him and has placed in him, and then to not allow her to die. Which brings us to the call, because obviously during this call she does die. And I'd contend to this court that she dies as a direct and proximate cause of the defendant's action or inaction. What do these messages tell us? What they tell us is that unlike all of these other times where Ms. Sparks and Mr. Birkbeil had engaged in this game, unlike all these other times Ms. Sparks was sort of taking the responsibility for her safety. She was taking it out of her hands, and it was being granted to and accepted by the defendant. She wasn't the one that was going to know which chamber was loaded, it was him. She trusted him to not actually allow her to die. We then know that despite that, she does pass away. A gunshot fired through the back of her mouth that was self-inflicted. And I'd suggest to this court that although the jury didn't see the actual play, what the jury sees in these messages allows them to reasonably infer what happened on this call. These messages show beyond any real doubt that this responsibility to identify the dangerous chamber, that fell to the defendant, that was their agreement, at least on September 29th, that this responsibility didn't fall to Ms. Sparks. The jury knows that these two agreed to do this together, that the defendant was given this duty and accepted this duty, and that Ms. Sparks died. And a reasonable inference for the jury to draw is either that Mr. Birkbeil saw which chamber was loaded and chose to say nothing, or that he just didn't carry out his duty very well.
Was there proof that she was blindfolded?
No blindfold, Your Honor, and perhaps inartfully in my brief, I at one point suggest that there was a blindfold, but she does say she could just close her eyes. That's what she offers up for doing, and she initially says that about 30 minutes before this call occurs. And then closer to 5 or 7 minutes before the call happens, she says she'll do it with her eyes closed.
Yeah, they're in separate states.
So no blindfold, but she does say she's going to close her eyes. And the jury can reasonably infer that she did what she said she would do. So I'd suggest to the court that when a person, like in this case the defendant, agrees to participate in such a wildly dangerous activity, that this agreement is sort of created between the parties with the specific understanding that the
This
defendant
may be the
has
first
this,
of its kind type of video.
I'll use the term broadly again, this sort of safety responsibility,
I mean, case, I don't know why it's a
and that
video.
ultimately one of the parties, in this case Ms. Sparks, passed away via a gunshot wound, which was intended to be the identification and prevention of the loaded chamber going off was the safety responsibility in this case. That is all a reasonable inference for the jury to draw based on what Mr. Birkbeil and Ms. Sparks said they were going to do. The jury could draw this reasonable inference and conclude that her death was proximately caused by the defendant, because if he had discharged his responsibility successfully or chosen to discharge it at all, her death could have been avoided. But that's not what happened. And I'd suggest, Your Honors, that that is sort of negligence in a nutshell. A person accepts this sort of responsibility and then in this wildly dangerous situation and fails to faithfully carry it out. That through all of these weird facts, that does get us back to negligence, and that's the crime at issue here. I'll briefly touch on on this First Amendment issue. Your Honors, this issue to me doesn't really smack of sufficiency. Your Honors, this issue seems to be an as-applied challenge to an as-applied First Amendment challenge here that was never litigated before the trial court. There was no mention of First Amendment protections anywhere in the trial record. The record is extensive, but nowhere in it is there any indication that the defendant thinks his prosecution somehow runs afoul of the First Amendment. And although the First Amendment is certainly a basis on which to challenge criminal prosecutions, what's clear is that constitutional sufficiency and constitutional First Amendment protections are different things. They raise different issues. They're dealt with under different standards. Your Honors, this is essentially an as-applied challenge that is that the defendant is seeking to sort of bootstrap onto a sufficiency challenge because he's waived his First Amendment challenge, but he can't waive his sufficiency challenge. By not asking the trial court to examine any of this on First Amendment grounds, he's waived that review before this court. Briefly, Your Honors, I'll address, presuming it's not waived, there is more than speech here. Certainly, Your Honors, there is a great deal of speech in this case, 10,000 text messages. But it is not
Criminal
the
Court of
speech
Appeals.
itself, but the agreements
just real
and
quick, turn
duties
'em over cases.
and undertakings and safety responsibilities that this speech sort of represents, that this speech really, in this case, what it is most properly viewed as doing is communication between the two parties about what responsibilities are, and it's certainly strong evidence of negligence about the failure to properly undertake these responsibilities, but it's the responsibility and the failure to execute it that is at the core of this case. Yes, evidence of it is speech, but simply put, using speech as evidence doesn't run afoul of the First Amendment. The defendant's conviction here isn't simply because he said any of the statements in his text messages. It's because he reached this agreement with Ms. Sparks. He had this duty and he failed to properly carry it out. As a final matter, Your Honors, on territorial jurisdiction, I think there is a great deal of agreement between the defendant and the state on how to approach this question. I think all parties agree that this offense was consummated in Tennessee. It's a homicide. The victim died in the state of Tennessee. Our only real disagreement seems to be, did the defendant directly reach out to Tennessee or use other means directly from the person, I think is how the statute specifically words it. And Your Honors, he simply did in this case. There was no accident in the defendant reaching out to Tennessee. He knew where Ms. Sparks was located. They talk about her location repeatedly throughout their messages. He knew where his action, he knew he was reaching out to the state, and that's the core of territorial jurisdiction. As I so often find at oral argument, it appears there's something I worded a little inartfully in my brief about deliberate attempts. The state's position is certainly not that this is, binding the state to use sort of an intentional mens rea for the terms of committing a crime. My only point there is that the defendant needs to,
All new to
the
me,
putative defendant
Crime
in a
Spice.
territorial jurisdiction case needs to have meant to reach out to Tennessee. And I think this really dovetails nicely with State versus Alderlin Johnson. Like opposing counsel said, there's not a great deal of case law on territorial jurisdiction. Alderlin Johnson is a good example of territorial jurisdiction analysis. What we had in that case was a second-degree murder prosecution stemming from a fentanyl sale. This was a fentanyl sale that occurred in Indiana. The defendant sold fentanyl to the victim. The victim then traveled.
Right.
Proof in that case shows completely unbeknownst and unexpectedly to the defendant, traveled from Indiana where the sale occurred down to the
traveled.
state of Tennessee, took the fentanyl, overdosed, and died. And what the court noted in Alderlin Johnson, court heavily quotes from a Kansas Supreme Court case. I'm going to quote some specific language from Johnson because I think that really gets right to the heart of territorial jurisdiction, and specifically the defense that is at issue in this case. So this territorial jurisdiction defense is for a defendant who was located outside the state, didn't intend to commit a crime within the state, and could not reasonably foresee that his act would cause, aid, or abet in the commission of crime within this state. Your Honors, it is entirely reasonably foreseeable by this defendant that his actions would cause this effect in the state of Tennessee because the person he's conversing with is in the state of Tennessee and he knew it. Yes, this is digital means. The defendant doesn't throw a rock across the border. He doesn't, mail a pipe bomb. He reaches out directly to the state of Tennessee digitally.
Phrasing.
This is the 21st century prosecution. Where we need to deal with territorial jurisdiction in the 21st century world. And in this world, one who digitally reaches out and does so directly falls within the jurisdiction of the state of Tennessee. The defendant's position really seems to focus on this.
This is dangerous.
Physical,
The dangerous president here. Because what if you had deemed hate
in a great
speech?
deal of cases, reaching directly out to Tennessee might be accomplished through physical means. But if I send an email to my father, I've directly reached out to him.
You gotta remember, it's
And
just
if I
his
know him
argument.
to be located in Tennessee, I've directly reached out to a resident of Tennessee in the state of Tennessee. So I've reached directly out to Tennessee. I think that notion, the state's interpretation of direct means, gels much more nicely with what this court indicated was the heart of territorial jurisdiction in Johnson, and the defendant's sort of approach that relies on on physical action is rather cramped and isn't fully cognizant of the way persons in 2023 interact with the world. If this court has no further questions.
You're
I'd
asking
ask
the court to
affirm.
do a lot right here.
Let me ask just one quick question.
Certainly, Your Honor.
And I believe I'm recalling this from the briefs. There was proof in the record that this defendant knew of the victim's fragileness I'll call it, that she was a fragile victim or individual.
Mm-hmm.
Is that correct?
Yes,
And
Your Honor.
In fact, at trial, did not her boyfriend testify for the defense to those facts, that she was fragile?
There
Her
was
boyfriend.
some
She had a boyfriend and this guy?
testimony from, not Mr. Burkebile, but from another man who who the victim was romantically entangled with. There was
How many
some
entanglements does she
testimony about
have?
her mental state. I'll note for the court that wasn't the only testimony about her mental state. I'll also note for the court that although this other boyfriend was speaking about her mental state, what the proof in the record showed at the time was that he was deployed overseas. So his knowledge of what her mental state would be like, I don't know that we can hold that out as perhaps the most shining example of accuracy, because he's not there with her. People at trial who were with her didn't paint such a bleak picture of her mental state as this defense witness did. Certainly there is some degree of mental illness and depression that seeps all through this case. But from the way the victim talks
Did you hear that?
in the moments leading up to her death, it
Mental illness.
does not read, her messages don't read as somebody who is imminently planning to kill herself. Some of the last things she does are share pictures of her pets with defendant and talk about how excited she is that her kitchen has been renovated.
Yeah, I don't agree
That
with you.
and other witnesses
Sorry.
that testified who were with her, who weren't across the ocean, that's a better picture of what her mental state might have been like. Thank you, Your Honors.
I knew some pretty healthy people that ended up
Thank you, General. Rebuttal?
having demons that nobody knew about.
I have 3 points I would like to make. The first, on the first sufficiency issue, I think that there's something to, I think maybe I like the state's
Right.
description of this as a play, in the sense that there was a script that the state has maybe deduced from the messages. But what the state's position on appeal is that what happened was that the parties followed the script through a bunch of the steps of the script, but that Mr. Burkebile departed from the script at some point, and that's how she died. And as I have said, that is an entirely possible thing that happened. But what a jury has to find is not that something is possible, it has to find that something happened, and that there is no reasonable doubt that it happened. Here, there is a multitude of other ways that things could have gone off the script. This could have been an accident. This could have been Mr. Burkebile, as he said, telling her, don't shoot yourself, stop, and her doing it anyway. It could have been them playing this game to completion, and then her shooting herself after the game is over. The idea that because she died, we can reason backwards that therefore they must have been playing the game in this way, and he must have seen the bullet, and he must have decided to keep quiet about it, that's just speculation. And because of that, it doesn't establish proof beyond a reasonable doubt.
I was going to say he's doing a reasonable
The
doubt.
second point to make is, again, just to clarify, I'm not making a
I'm a mouthful. I
standalone
wanted to
First
say that.
Amendment argument. We're making a statutory interpretation argument. We are using the principle of constitutional avoidance. Tennessee Supreme Court recently cited to that in State versus Booker as a perfectly legitimate way to interpret a statute. In fact, it's better not to say we're going to interpret a statute broadly, but then say it's unconstitutional. The better way is to interpret a statute so it doesn't even go over to where the Constitution reaches.
Yeah, right.
The final point I want to make is on the territorial jurisdiction. I think there is clearly a difference of how to interpret the relevant phrase. I have put forth a interpretation in my brief. The state has its interpretation of the brief. Other means proceeding directly from the person. To me, that speaks of from the person. It's not so much directly, but from the person has to do with something physical. The state says no, emails proceed directly from the person. But there is and I didn't bring this up in my original argument, there is a solution to that problem when you have a phrase that is susceptible of different meanings. And in the penal criminal context, that solution is the rule of lenity. And here, where this phrase can be interpreted, I think reasonably in both ways, the appropriate solution is to say, for now, we will interpret it in favor of the defendant. If the legislature thinks otherwise, if the legislature thinks in the 21st century we need to make clear that this covers electronic communications, the legislature can do that. But when it has not done so, the rule of lenity says that this interpretation should be done against the state in favor of the criminal defendant. And in that situation, we simply do not have territorial jurisdiction. So we would ask that the court enter a judgment of acquittal on the one charge against Mr. Birkbile. Thank you.
That was a
Thank you, Mr. Harwell.
100% correct.
Well argued and
statement.
well briefed. We'll take the case under advisement. And I think that
If it's vague,
concludes our docket
can't
for this
imply.
afternoon. So we'll be at recess until tomorrow morning at 9:30 a.m.
that's it.
All rise. This honorable court of Tennessee stands adjourned until 9:30 tomorrow morning. Thank you.
All right. I'll get out of that. There we go. So, that was a cool one, man. Who thought that was going to happen, right? So, are you liable for something you say? Free speech. Are you supposed to know somebody's mental abilities? Right? I mean, are they in a good place? Why can I not get situated here? I feel like I'm falling down in my chair. You know why? It's because I've been moving stuff. See, look, I moved everything down. Yeah, trying to get everything situated here. That's why Brown Dog, he finally left. Anyway, so yeah, what's you know, the theme song to the movie MASH. Anybody know what that is? Suicide is painless. The name of that song. Should it be held liable if somebody does that? So, I mean, I don't know. I don't know who this chick is. I'm no professional. I mean, you know, there's a lot of people. Hey, look, I've dated a lot of chicks that were crazy. All right. You don't know they're crazy. You know, so you ladies, you've dated a lot of dudes that were crazy. You didn't know when you went on dates with them. But it's the level of crazy. And here's the thing. If anything should be held liable, when do you think the first idea of it being a kink to put a firearm to your head? Who did that? Who's the first person to do that? Hey, baby, he's this sexy. Right? So maybe this is a greater thing about like that's just the internet, man. Like this is the wild internet. Now all of a sudden, everything is all crazy, and it's you got to do all this stuff. I don't know. Problem is that this screen, people confuse real life with like movies and television and everything. It's I don't know, it's sad. I think this is sad on a lot of different sides. You know, you feel bad for her family, you feel bad for his family. You feel bad for her, feel bad for him. Then we got this random guy who's on deployment. He's just overseas. And it's like, wait, what was she doing? What was my girl doing? That's awesome. start over. So I don't know, man. All this stuff is just wild. It's bad stuff, bad stuff. But then you had the guy with the kidnapping of his wife. That guy belongs in jail for a long, long time. And then what was the first trial? The first appeal? God, I already forgot it. Brain's gone. I was so focused on being hungry that I didn't care. Ugh. So anyway. Oh yeah. Hey, did you guys see this? Hang on real quick. Since I got y'all here. I don't want to do this tonight, but tonight we're gonna have a good time. Um I think there we go. Hey, look, tennis shoes. No. So the Audrey Cunningham's alleged killer. Man, I wish I could get this part off the screen. There you go. Don Stephen McDougal. Oh yeah, there we go. Here's video, body cam video. Open up a cell. It's like, what are you doing? I have no clothes on. No, hang on, there's volume to it too.
Your smock on for that. Well, come on out here.
Listen, let me rewind that for you.
Come on. JP wants to talk to you. Where's your clothes? Hold on.
I ain't got no clothes.
Well, put your smock on for that. Well, come on out here. Well, no, man. Come on, man. Don't disrespect me like that. All right, well, wrap up in that. Wrap up in the blanket. Come on. Come on.
Go back to bed.
Steve, come on. Let her arraign you real quick. Come on. Huh?
Yeah, no,
You gotta
elephant.
get up and sign some paperwork. Come on.
I come back over here, I ain't signing shit.
Come on, wrap up for me. Appreciate you. Here, I'll hold it.
All right, Mr. McDougal, I'm Judge Richardson. I'm going to read your rights, and we're going to talk about your charge today. You have the right to remain silent, not make any statement at all, and know that any statement that you make can and will be used against you at trial in court. You have the right to have an attorney present to advise you prior to or during the questioning. If you can't afford one, you do have the right to have an attorney present to advise you or during any questioning. You have the right to terminate any interview at any time, and you have the right to examine your trial if you're accused of a felony. Do you understand your rights, Mr. McDougal?
Yep.
Okay. Do you want a court-appointed attorney, or you going to hire your own?
Nope.
Which one?
I'll get a attorney.
You gonna hire your own?
Yep.
All right, all I need you to do is sign right here for me. Your charge is capital murder, and it's a no bond.
Okay, thank you.
Okay, good night.
So what a great individual. And he was the babysitter for Audrey Cunningham. Here's the article. The swastika tattooed suspect in the brutal murder of 11-year-old Audrey Cunningham refused to wear clothes for his arraignment. Eventually appearing in court with only a blanket around his waist, shocking new video shows McDougal was completely naked in his cell last Wednesday when shocked Polk County Sheriff's deputy came to take him to the hearing. Come on, Justice Peace wants to talk to you. Where are your clothes on? Hold on. I ain't got no clothes, replies McDougal, whose large swastika tattoo could be seen clearly on the left of his shoulder. Come on, man. Don't respect me like that. Well, wrap up in that. Wrap up in that blanket. The suspect, who is charged with capital murder later, appears to be smirking when he stands before the Justice of the Peace, wearing nothing but a blanket around his waist. He is then read his Miranda rights and asked if he wants a court-appointed attorney. I'll get an attorney, the alleged killer tells the official. You're going to hire your own? All right. All I need you to do is sign right here for me. Your charge is capital murder. That's no bond, the justice tells him during a surreal exchange. Audrey of Livingston, Texas, was found tied to a rock at the bottom of the river 6 days after she went missing. I didn't know that. Didn't know that. She's last been seen with McDougal, a friend of the family, has a lengthy rap sheet including prison time for enticing a child. He is living on the family property in a camper, according to charging documents. He frequently walked the girl to her bus stop before allegedly murdering her and dumping her body in the river in the horrifying crime. McDougal, a reported neo-Nazi with ties to the Aryan Brotherhood, was first taken into custody on an unrelated assault charge for an alleged stabbing on February 16th and was sitting in the Polk County Jail when cops found the body. Meanwhile, Audrey's family has released a statement expressing their grief and gratitude for support from the community, but also saying the system failed them. Audrey Daniel Cunningham was lured under false pretenses, which led to a senseless act of violence occurring and ultimately to her death, they said in a statement. Tragically, Audrey's death occurred in the hands of a monster we thought was a friend only 10 days after Audrey's 11th birthday. Fortunately, the system failed us due to a loophole in the sex offender registration system. Don Stephen McDougal had a history of disrespect for young female children, but it did not show up when we checked the registry before allowing him to stay in an old camper in our backyard while he tried to start a new life. Yeah, you know what? I'm going to throw up flags of BS right there, okay? That's complete BS. If you know somebody who is tatted up with swastikas and everything else, okay? That dude's on a registry somewhere. I'm going to tell you this right now. If you think that you're going to help them start a new life, what life are they going to start? Huh? What life? What are you trying to promote for them? You don't need to get involved. Okay, that's the key. Don't get involved. If you have kids, your one duty is to protect those kids. Okay, you are supposed to be their heroes from keeping them away, keeping monsters away from them. Don't be an asshat that brings them into your house, onto your property, lets them walk the child to school. Ugh. These parents deserve to be tied to a rock. Sorry, guys. Had we been aware of what we know now, this man would never set foot on our property, much less been part of our little girl's life. Yeah, okay, well, that guy didn't learn how to. Guess he was just born. That's not a tattoo. That's a birthmark. Right? You know what's funny? No Nazi had a tattoo like that. Yeah, you think if they did, you'd be seeing it, right? You'd be like, "Oh, look at Hitler's tattoos." Yeah. Anyway. I hope he doesn't make trial. I got better stuff to do. Guys, we got trivia. It'll be coming up later.
Well, I woke up to go get me a cold pop,